Ian Paisley.
Thank you very much, Madam Chair. It's an honour to serve under your chairmanship, and it's also an honour to follow the speech from my colleague Sammy Wilson. The member for Lichfield posed a question, which I suppose he thought got to the nub of this, and which was around the lines of, well, if you were back in Stormont, you could sort this out yourselves. Basically, sod off and do it. I mean, that's the implication. Madam Chair, this has nothing to do with Stormont. This has everything to do with how law should be applied consistently across the United Kingdom and how law should be made, whether there is a Stormont in place or not. And I was hoping that the Secretary of State would have answered a series of questions that have been posed, because delegated legislation committees, by their very nature, Madam Chair, as you will know, usually happen in less than a quarter of an hour. Matters are agreed and it goes through because law is being applied consistently. And I would have hoped that the Secretary of State would have taken some time to address some issues, because this particular piece of delegated legislation was subject to a special scrutiny called the 44th report by the Secondary Legislation Scrutiny Committee. And it posed a whole series of questions for the Secretary of State to answer. It actually said, I hope the Secretary of State answers the following, and listed a number of questions. And I was hoping that he would have answered them, save me having to speak. Or that the Shadow Secretary of State would have maybe posed those questions too, to the Secretary of State. But it appears that that report, which I have in my hand, has fallen deaf on those who are here to hold the Secretary of State to account. And I'm not a voting member of this committee, but I will pose the questions that I have been asked, because I also asked a question of the Secretary of State, and he promised he would come to that question about Section 76, and he didn't bother. Wasn't in his speech. He didn't bother answering the question, because I know what the answer to the question. I was told a very long time ago, never ask a question unless you know the answer. And the answer is patently obvious, because the Secretary of State knows that he couldn't give an affirmative answer to the question that I asked. This report, Madam Chair, details 5 issues, 5 questions. They deal with the implementation, that the implementation of the schedule is rushed, that there has not been a full public consultation comparable to when similar policy changes were made in England, which again is contrary to what the Secretary of State said, that regulations to ensure that parents have a right to withdraw will not be in place when the policy is implemented. The Secretary of State has indicated that's a matter for the Department of Education, again something very different from what has been in place in England, and that what constitutes age-appropriate, comprehensive and scientifically accurate guidance has not been defined, and what will actually be taught. And fifthly, that the regulations were brought into force the same day that they were laid. It actually breaches the convention that at least 21 days should be allowed between the laying of an instrument and the bringing them into effect. And my colleague from East Antrim has dealt with that, so I won't actually go into that particular point. But essentially, the Secretary of State is duty bound to make good policy. This 44th report of the Secondary Legislation Scrutiny Committee says that this is bad policy. And that might come as a surprise to a number of his backbenchers, that they're being asked tonight to vote for something that their government, in the other place, says is bad policy. And I think that should maybe just cause some time for them to reflect. And I want to deal with a couple of the issues that the report puts on the record. So, in terms of the issue of why does the Secretary of State believe, and I have this question for the Secretary of State, why does he believe that this is not rushed policy? Whenever the 44th report says, and I quote, "Considering these points together, we are concerned that the implementation schedule has been rushed." It goes on to say, quoting paragraph 28, that when taken alongside the other concerns on timing, the House may wish to press the Minister to bring forward the necessary legislation to push back the implementation date. This could allow time for a public consultation and would ensure the policy can be fully developed. And I would want to know why the Secretary of State hasn't considered that point that was made by his colleagues in the other place and the advice that they gave to him after there was serious scrutiny made of this piece of delegated legislation. I'd like to know if the Secretary of State can tell us what will actually be taught. And he can't tell us what will be taught. And he's already confirmed that he can't tell us what will be taught. But in paragraph 43 of the report, it says, when the Scrutiny Committee asked the Northern Ireland Office how age-appropriate, comprehensive and scientifically accurate guidance would be determined, the Northern Ireland Office responded that this was a matter for the Department of Education. The report concludes that on such a key point, this is not an illuminating response. On such a key point, this is not an illuminating response. At the least, it would have been helpful for the Northern Ireland Office to have liaised with the Department of Education to provide more detailed information. Questions now remain about how this aspect of the legislation will actually be implemented. And I'd like to know how the Secretary of State intends to do that, because what is actually taught goes to the crux of this matter. So, for example, if a child asks the question, is it possible for me to have an abortion on the basis that I don't want to have a child? Or financially, it would be too much burden. Can the Secretary of State tell us, would those questions be allowed to be asked and answered? Because the law prohibits a person having an abortion on the basis of it's not financially my concern, or I don't financially want it, or I just don't want the child. They have to actually have a specific legal reason. But can the Secretary of State answer, will those matters actually be taught? Will that be brought out? Or will it just be, can have an abortion for any reason? And the Secretary of State knows that those matters have not yet even been addressed in any way by drawing up a schedule of what should be taught. Thirdly, in terms of the right by a parent to withdraw their child, can the Secretary of State deal with this issue? The 44th report puts it this way. It says that the House may wish to inquire further of the Minister why the instrument does not place a duty on the Department of Education to have regulations in place to facilitate parents withdrawing their children from sexual education by the implementation date of the policy, and what steps the Northern Ireland Office is taking to ensure the Department of Education does in fact have these regulations in place. In terms of the conscientious objection by teachers, the report says that they asked the Northern Ireland Office whether teachers would have the right to conscientiously object to delivering the approved material. Again, the Northern Ireland Office said that this would be a matter for the Department of Education, although the Northern Ireland Office noted that a large majority of schools currently outsource RSE to third-party providers. What steps is the Secretary of State taking to consult with outsourced RSA? Most scripture unions are outsourced across schools. Would those schools find that those organisations find they are in breach of the law? What protections would be put in place? What rights would be put in place to protect outsourced RSA? And of course, I will give way to my colleague.
And in fact, would you note that in the report, the point which is being made is that the outsourcing was one of the things that CDAW complained about, because they said that the outsourcers were the people who were bringing the values into these things as well.
Thank you, member, for expanding on that point. There is no guidance presented this evening by the Secretary of State on this issue of objection. What about teachers who wish to object? The report goes into this issue and says that, for example, on how key terms will be interpreted on the rights of teachers to conscientiously object on funding has not yet been determined, or at least has not yet been made available to Parliament. And it highlights this, the report highlights this in bold. This is unfortunate. It would have helped if the Northern Ireland Office had liaised with the Department of Education to ensure more detailed information was available, even on matters not specifically under the responsibility of the Northern Ireland Office. The House may wish to press the Minister for further specifics. So, Minister, I press you, can you give us the further specifics that the report, that your colleagues, that the Secretary of State's colleagues in the other place signed up to and posed these questions about? Because it was totally absent from the speech that was laid before this House. And the Secretary of State has a duty in these delegated legislation committees, or the Minister has a duty in these delegated legislation committees, to answer such questions. Now, the Secretary of State in his comments did say that this matter complied with the Northern Ireland Act, but he failed to explain how. And the reason why he failed to explain how, Madam Chair, is because it does not comply with either Section 75 or Section 76 of the Northern Ireland Act. This discriminates against religious education. This is not neutral. What is being proposed by the Secretary of State is not a neutral policy. It's a specific policy that, in effect, regardless of the ethos and religious or moral values of a head teacher or a board of governors or a school, that certain things will not be allowed to be taught because they are of a religious nature. And the Secretary of State has failed to do that. And the Secretary of State really needs to go back, because he will, and the Northern Ireland Office will find themselves ultimately in court on this matter, because he knows how litigious lawyers are in Northern Ireland on Section 75 and 76. And for a government that has nailed its colours to the mast on protecting the architecture of the Belfast Agreement, here we have something which rides a coach and horses through two of the most important protective rights, Section 75 and Section 76 of the Northern Ireland Act. And I fail to see how the Secretary of State could have answered the question that I posed to him with the words, yes, I will come to that in a moment, I address this in my speech. The Secretary of State didn't address it in his speech because he can't come to that point, because he knows, the Secretary of State knows in his heart, that this breaches 75 and 76, Article 75 and 76 of the Northern Ireland Act. There's then been the point raised by a number of members, oh, this is the same as England. Suck it up. Suck it up, guys. This is what happens in England. That's what it's like. Well, of course, this is not the same as what happens in England. And if it was the same, we would be asking the Secretary of State to at least then do what is the same. And this is what the report says. Don't take my word for it. Take the words of the members of the government party in the House of Lords, or in the other place, when they say this in paragraph 54 of this report. It is striking that full public consultation were carried out when comparable regulations were introduced in England, and when similarly controversial regulations on abortion were introduced in Northern Ireland. The NIO has not offered any convincing reasons why these regulations should be treated differently. These are not my words. These are the words by the 44th report. And I really am surprised why the Secretary of State thought he could bluff this through tonight. And I am as equally saddened that the Shadow Secretary of State didn't challenge at these matters, because these are key issues that need to be responded to. It's not the same as England, as the report says. It's striking that it's not the same as the report says, and that these regulations are being treated differently in Northern Ireland. My colleague from East Antrim went into a number of the submissions raised by the Catholic bishops and raised by the Presbyterian Church, raised by boards of governors. I don't intend to dwell on those points, but I will say this. This report blasts what this House is doing tonight by calling it bad policy. In paragraph 56 of this report, it says that to improve a policy, we can help to improve confidence in a policy, and we must work to do that. And it says this, given, I quote, given that this is a controversial policy with a wide range of interested parties and strongly felt views, a public consultation would have been appropriate as a matter of good policy making. It would have been good policy good practice, the appropriate thing to do, to have the consultation, to put the horse in front of the cart. But oh no, the Secretary of State has tonight said, oh, there might be a consultation later on. I'll just rush this one on through. I think that the Secretary of State should really take time to read this. And the Secretary of State could tonight pull this, and he could decide, well, let's then put this out to consultation. He's under no pressure whatsoever. I am sure the Shadow Secretary of State would support a consultation on this. I didn't hear any reason why he wouldn't. And I think that there's well been other members in the government's own bench who have indicated to me that they feel this is a conscience issue. So why doesn't the Secretary of State go, and I put it to him tonight, why doesn't he go for a consultation and come back to this matter after the consultation if he's so convinced that he has it right? After all, he has the persuasive argument from the Secondary Legislation Scrutiny Committee that they strongly believe that this matter should be put to consultation. I've never seen such a report from a legislative committee in my life in the last 14 years in this House. This castigates colleagues in these benches, this castigates the government for not doing this, and we should be cognizant of that fact. This isn't some minor thing. This is about policy being made, and this doesn't really matter if we're talking about abortion or if we're talking about the education around abortion. This is about the mechanism of how policy is made, and the government has got it wrong tonight. And I would urge colleagues to really consider that and say to their government, and say to this government, let's do the right thing here. Let's get the consultation right. The former Solicitor General in these benches, I'm sure he knows that when something like this is being done, it is not right. And I would encourage colleagues to press their government on this issue. In paragraph 60 of this report, it says on the 21-day breach that this House may wish to press the Secretary of State, or press the Minister, for further justification on why the 21-day convention was breached. We ask the NIO to consider carefully any possible future breaches of this convention. Why, Secretary of State, have you breached the 21-day rule? You're under no obligation to do that. You've breached it. There's lawyers in these benches. I'm sure they would want to know why the Secretary of State has done it. What's the compelling reason, Secretary of State, for breaching the 21-day order? It just appears absurd to me why this has happened. It would have been helpful if the Northern Ireland office liaised with the Department of Education to ensure that more information was available, was how this report concluded. Madam Chair, what do these regulations do? Very, very briefly, Madam Chair. They will force all schools, regardless of their ethos, their religious background, their moral views, the views of the head teachers, board of governors, etc., to teach children between the age of 11 and 16 years of age that they have the right to abortion. That's the law. That's what we teach them to do. And how to obtain one. And how to obtain an abortion without their parents' consent. That's what it will do. It will remove parental responsibilities in this. It will prohibit further the presentation of any opinion opposed to abortion. And the explanatory note, which is in front of us tonight, states that schools must not, and I quote, advocate or promote any particular opinion on sexual and reproductive health and rights in accordance with the recommendations in the report of the inquiry concerning the United Kingdom, Great Britain and Northern Ireland under Article 8 of the optional protocol to the Convention of the Elimination of All Forms of Discrimination Against Women, in other words, the CEDAW report. Forcing religious discrimination, forcing schools to promote and facilitate abortion is not a neutral or value-free position. The government is forcing schools to take on a position that is not normally theirs. And these regulations, therefore, are aimed at exclusively at suppressing the expression of a particular viewpoint. And it threatens the conscience and the rights of teachers, of school boards of governors. It is against Article 9 of the Convention of Human Rights. It also contravenes the terms of 76 of the Northern Ireland Act 1998, which prohibits public authorities, such as the Department of Education, from discrimination based on religious belief and political opinion. Secretary of State, if you want to end up, if the government wants to end up in court, they will end up in court by pursuing this evening. And I would encourage them to pull back from it and to get this right. Section 75 of the Northern Ireland Act, on the other hand, recognises the particular religious character of the role played by boards of governors in Northern Ireland when it lists them among the institutions exempt from the statutory duty to have due regard for the need to promote equality between religious beliefs and political opinions. So we're asking, and I'm asking the Irish State to keep the law, to make good law, to make law consistent with what was laid down in 1998 and not to drive that law in the opposite direction. The regulations have been condemned by both sides of the community in Northern Ireland, and that point has been made well this evening. Secretary of State, can I just say that these regulations seek to impose an ideologically based view on abortion on schools in Northern Ireland, contrary to the legal protections against religious discrimination. They are also being rushed through without consultation and in breach of parliamentary convention. This is bad law. I would ask the Secretary of State to pull back from this tonight and to make good law.